Welcome to the class on public international law. This is Asylum and Extradition. This is Dr. K. Sangeeta. So, as to the continuation of Asylum and Extradition, the next case law is de-attentat clause. The de-attentat or the clause Belge states that murderers of heads of government or states will not be considered as political crime as they can be extradited for such a crime. Rule of speciality. The doctrine of speciality is a doctrine under international law. It states that person who is extradited to a country to stand a trial for certain criminal offences may be tried only for that offences and not for any other pre-extradition offences. For example, A has killed B, and if he is extradited for that offence, he should be only tried for that murder of B. Instead, if he has committed a murder of C or D, that should not be tried herewith. This principle was restated in the case of US versus Rocher, which states that he can only be tried for the offence which has been criminalized by the treaty or the offence for which the extradition has been requested for, not for any other pending case against him. Next is doctrine of double criminality. Double criminality is a principle that states that criminal can only be extradited to another country if the offence has been committed is criminalized by law for both the countries that is involved. Example, if a murderer has run away from Bangladesh and is hiding in India, he can be extradited as the laws for both the countries for murder is criminalizing or conducting trial and punishing the murderer. We will see another example. If a person has committed bigamy is an offence in India, so he may be tried in India. But if he is in Pakistan, bigamy is not an offence in Pakistan, so such case it is not possible. So the crime should be considered as crime in both the countries. Position of the state in international law. It must be noted that the state has no duty to extradite an individual. There can be a treaty between that states that they will extradite any criminal that run away from their country or vice versa. They can also voluntarily extradite a person without any treaty. States should keep in mind that during extradition they should not violate their own municipal laws of their own countries and international conventions. However, countries do not have to give the fugitive back if the proper extradition procedure was not followed. In Sarvarkar case in 1911, Vinayakar Donadar Sarvarkar was under the French Navy custody. He was then extradited to England, but England obtained him through incorrect extradition procedure. Due to the violation of the procedure, the French wanted him back. The court held that there is no provision under the international law that the states, if extradition procedures are not followed, then the country must return him back. State can also not extradite citizens of their own state. If a citizen of the England comes to India, commits a crime, runs back to England, then it is very difficult to get the citizen back. They usually ensure that they will punish the criminals according to their own law, according to their local laws. In Regina versus Wilson in 1878, a treaty can happen between two states. States will not extradite people and the fugitive that will be punished according to their own laws. The stand in India. Usually each country has its own laws regarding the process of extradition. In India, the Extradition Act 1962 governs the process of extradition. It was amended in the year 1993 by Act 66. According to this, Section 2D of the Act talks about the treaties for extradition, which allows the foreign state to make such arrangements with India. These treaties are usually bilateral in nature. They are between two countries, not more. These treaties embody 5 principles. Extradition of a fugitive will happen for offences set down by the treaty. The offence must be criminalized under the law of both the countries, not just one country alone. There must be a prima facie case that is made. The country should try the criminal for only the offence he has been extradited for. He must be tried under fair trial. Usually, requests for extradition on behalf of India can only be made when the Ministry of External Affairs and not anyone in the public. Countries who have a treaty with India can request extradition of someone in India. A non-treaty country must follow the procedure set down according to Section 3(4) of the Extradition Act of 1962. According to the Ministry of External Affairs, below are the following bars of restriction to extradite. India is not obliged to extradite someone unless there is a treaty. India is not obliged to extradite someone unless that offence constitutes a crime under the treaty. Extradition may be denied for purely political and military offences. Offence must constitute a crime in both India and the country requesting extradition. Extradition may be denied when the procedure set down under 3(4) of the Extradition Act 1962 is not followed. Next we will see what is asylum. Asylum is when a country gives protection to an individual who are being prosecuted by another sovereign authority. Most of the time it is their own country, while everyone has the right to seek asylum. Asylum seekers do not have the right to receive it. It must be noted that asylum deals with refugees, individuals who are being prosecuted by their own country.